pleasure to introduce our closing keynote speaker to you, our very own Professor Deborah Rhode, who is the Ernest McFarland Professor of Law here at the law school. She's the director of the Center on the Legal Profession, also director of the program in Law and Social Entrepreneurship at Stanford University. She is not one of the most frequently cited scholars on legal ethics, but she's the one most frequently cited scholar on legal ethics. She's the author and co-author of over 30 books in the area of professional responsibility, leadership, and gender. Her recent publications include Trouble with Lawyers, Lawyers as Leaders, Legal Ethics, Gender and Law, Moral Leadership, and Access to Justice. She has received numerous awards, including the ABA's Michael Frank Award for contributions to the field of professional responsibility, the American Bar Foundation's Award for Distinguished Scholarship on Legal Ethics, and also the Outstanding Scholar Award, and she's also been the White House's Champion of Change Award. She received that award for lifetime work in increasing access to justice. Professor Rhode graduated summa cum laude from Yale College and received her legal training actually at Yale Law School. She clerked for Justice Thurgood Marshall, and after her Supreme Court clerkship, she joined the Stanford Law School faculty. So Professor Rhode will talk about access to justice and legal services for routine needs, new technologies meet bar regulators. So without further ado, I'll turn it over to Professor Rhode. Please, sir.
Thanks so much. I'm such a supporter of Codex and all of the work that's done here and done by all of you. And I hope it will come as no surprise to people in this room to suggest that we're in the early stages of a technological revolution in legal services, which is displacing lawyers in a wide array of tasks and also reshaping the way that lawyers find clients and deliver assistance. For most consumers, these are welcome developments. Innovations generally reduce costs and increase both accessibility and efficiency. And the potential gains are particularly great for low and middle income consumers who lack access for a vast array of basic, often urgent needs. But for lawyers, the consequences of technology have been more mixed. Many feel that their professional independence and livelihoods are threatened by the growth of online forums, computerized algorithms, and price competition among internet providers. And in response to these concerns, bar regulators have often fought back through ethics rulings that attempt to rein in organizations like LegalZoom, Rocket Lawyer, and Avvo Legal Services. In these brief comments, I want to explore some of the contested technological terrain of legal services for low and middle income Americans and the bar battles that are brewing. For 40 years, I've been arguing that the profession should be trying to learn from innovation, not stifle it, and this talk is in that vein. It draws on a paper that I co-authored with Ben Barton, forthcoming in a law review symposium. Happy to give people more information about that. But to put the current issue in perspective, I just want to start with a brief story about how I got interested in this field and, in fact, even in being an academic. I was a first-year law student at Yale working in a legal aid clinic that wanted to deal with the problem of inadequate services for its family law clients. The family law unit of that legal assistance program did intake one morning a month. And if you were a poor person in New Haven and you didn't show up on that morning and you didn't get a free lawyer, either you didn't get a divorce or you had to pay what would now be the equivalent of over $1,000 for a lawyer to complete 3 basic forms and show up for a 5-minute hearing. The clinic decided it would put together a do-it-yourself kit, there were none available at the time, and give it to some clients that it felt could probably manage without in-person assistance. And when the local bar association heard about it, they threatened to sue the clinic for unauthorized practice of law. Clinic had never heard of this, and I, as a first-year law student, was dispatched to find out if there was any basis for that claim. And in fact, at the time, there was. There was a precedent in New York that said because kits were practicing law in lieu of a lawyer, they could be banned under unauthorized practice doctrine. Well, even though I was just at the beginning of my legal career, this struck me as ludicrous and outrageous, and especially for our clients who had no money to divide up. Usually the partner was long gone, and they just needed help with the forms, and no lawyer was willing to supply it at a cost they could afford. But the legal aid clinic didn't want to tangle with the local bar association, so they didn't put out the kit. Fortunately, a women's group at Yale was not so intimidated and basically told the bar association, sue us, you take the coffee pot. And the bar decided it didn't want to tangle with these, flaming feminists who had no distribution system anyway. And so the kit went out, and I managed to find about 100 people who actually used the kit. And spent the next couple of years in law school doing an extensive empirical research project that, first of all, looked to see whether those kit users made any more mistakes on their forms than lawyer-assisted divorces. That required a survey of 400 files in the Bridgeport courts. I don't recommend the experience, but the bottom line was very satisfying. No, they didn't make more errors. And the lawyers pretty much had their secretaries do it anyway, so a clerk would send it back to whoever made the mistake, and it wasn't usually a huge deal. I also interviewed 100 kit users and 100 clients of lawyers to find out whether the kit users were missing out on important legal advice that the client-assisted consumers got. Answer, pretty much no. 80% of them didn't get any tax advice or much advice of any kind from the lawyers. They just did the forms. So the bottom line was a very long tome in the Yale Law Journal saying people should have access to kits. And as student projects go, it had some legs because there began to be a series of fights over unauthorized practice doctrine. And that study was frequently cited for the proposition that we shouldn't be barring kits. And of course, now we don't. And much has changed in the now 40 years since I worked on that article, but much has not. And the bar is still suing its competitors under unauthorized practice doctrine for reasons that I think have a lot more to do with the profession's interest than that of the public's. And I've spent a good part of the ensuing decades writing just about every 5 or 10 years another article about how wrong this all is. And for those of you who haven't been following the skirmishes, I'm going to just start by summarizing one of the most contested recent cases, and then close with a few recommendations of how and why the bar should get out of the way, and then open it up to questions and comments from all of you. And the central argument that Ben and I make is that lawyers should embrace the inevitable. Technological innovations, as all of you know, are here to stay, and the profession needs to be looking for ways to harness their potential to serve underserved constituencies that need it most. The best estimates now are that over 80% of the legal needs of the poor and 40 to 60% of the needs of middle-income Americans remain unmet, and those figures haven't really improved over the last 3 decades. According to the World Justice Project, the United States ranks 67th, tied with Uganda, of 97 countries in the accessibility and affordability of civil justice. And a large part of the problem is cost. And the fact that people are still asking the question in this cartoon. We must do better, and technological innovations are part of the answer. And we also argue that purely from the standpoint of professional self-interest, lawyers need to learn how to compete in today's new technological reality of self-help and online services. That means learning how to do more legal work for less money by reducing the amount of time spent finding clients and managing their businesses. And Avvo Legal Services, which is going to be the focus of my remarks, is an example of how lawyers can compete with technology by using it effectively. And that, we suggest, is the path forward for the profession. That service is an example of how to market routine legal services delivered by lawyers, not machines. And instead of trying to smother the attempt, which most bar regulatory committees now are, lawyers should find ways to make it work. Because one way or another, technology is going to increase competition and reduce prices in the market for legal services. And either lawyers need to get in the game and use technology to compete against online forms, or they're going to be leaving the field open for computers to dominate. Avvo Legal Services and the inevitable imitators that we think will follow are an opportunity for bar regulators and lawyers to do well and do good, to expand access to justice at the same time as we make lawyers more competitive with machine-driven legal services. So let me say a word about how it works. I know that this audience needs no help from me, a self-acknowledged Luddite, concerning evolutions in the market for low-cost routine services. We now have a universe of interactive legal forms available for sale by LegalZoom, Rocket Lawyer, and other similar services, and forms available for free through the court-sponsored websites and programs. Technology is also reshaping the way that consumers find and retain lawyers. Traditionally, of course, it was through personal referrals and Yellow Page ads, but now it's online. And many new online providers are offering low-cost monthly plans or initial consultations with lawyers. But the rank and file of the organized bar has not always been eager to embrace these opportunities. And at first, that allowed early adopters to capitalize on technological innovations without attracting a lot of competition or even regulatory attention. Bar regulators didn't get around to trying to stem LegalZoom's provision of online forms until 2007, long after the company was already well known and impossible to dislodge. And suits charging that company with unauthorized practice of law generally failed. But by contrast, now bar regulators realize they need to get off the dime, and they've used their leverage to try to ban lawyers from participating in services that market lawyers' advice, and in particular have gone after a new Avvo legal services plan. And I'll say a word about the business model for those who aren't familiar. As some of you may know, Avvo began in 2007 as a lawyer rating service. And I should note at the outset that I was somewhat involved with the company and that I provided pro bono advice to the founders about what consumers wanted when shopping for lawyers and how the company might avoid problems with the bar. And because sometimes virtue is not its only reward, the founders gave me some stock options in the company that I actually forgot about until I began working on the article. And it turned out, coincidentally, that Avvo was just acquired by a larger organization, and those options turned out to be worth a chunk of change, which I've now donated to nonprofits working on issues of legal ethics and access to justice, so I don't have a financial interest in anything I'm about to say. But as an ethics professor, I just wanted to be candid about my own support of the company at an early point. Although in its recent run-ins with the bar, it's a completely different set of issues, because what's at stake now is not the rating service, but the provision of a matching service that couples lawyers with consumers seeking low-cost advice. Initially, what Avvo did was provide consumers with as much public information on lawyers as it could. And it got information from bar disciplinary authorities and lawyers' own websites, and eventually provided a rating structure for individual lawyers based on the data it could collect. Its revenue, however, didn't come from that. It came from lawyers who purchased advertising on its site that was designed to reach clients. So in order to stay successful, Avvo needed to keep drawing in potential clients, because without their eyeballs, lawyers would have no reason to buy advertising on the site. So to that end, Avvo began expanding its services. First, it provided free legal help in the way of searchable legal advice in the form of brief questions and answers by Avvo volunteer lawyers. So you could go onto the site and get somebody to answer a question within 12 hours. And at first this seemed kind of puzzling. If Avvo was making money from lawyer advertising, wouldn't free legal advice or free forms, which it went on to provide, undercut that business? Well, apparently not, because what Avvo really wanted was to be the first and hopefully only site that most Americans with a legal question or a problem went to. And providing some free services was a way to drive traffic to the site. And then some visitors would decide that they did, in fact, need a lawyer, and they would browse for one right there on Avvo. So by this fall, Avvo claimed to be offering free legal guidance to a customer every 5 seconds, and to have some 11 million searchable legal questions and answers. It also allowed lawyers to create longer legal guides that provide overviews in the area. So they not only have these question and answers, but they give you little surveys of topics: bankruptcy and debt, business, criminal defense, et cetera. And the part of the service that's now driving the competitive concerns from the bar are two other services that involve paid lawyers. The first is called Avvo Advisor, which offers a 15-minute consultation with a lawyer from a person in the same state in the desired field for a one-time fee of $39. Avvo promises that those lawyers who volunteer to provide this service will have years of experience and high client ratings. Customers who choose a different service, now LegalZoom and Rocket Lawyer also offer legal advice plans, but theirs is a subscription service, not a single flat fee consultation. So here's how Avvo works. Once a month, Avvo pays out any collected fees to the lawyers who provided services, and then withdraws a $10 per consultation marketing fee from the lawyer. So the lawyer ends up getting, for the initial consultation, a net payment of $30 for 15 minutes of work. And this, of course, is not the level of income that lawyers were expecting when they went to law school. And so why would they be involved? Well, for one thing, a lot of struggling lawyers felt like getting anything for this advice was good news, because it would up their chances of being hired by the client for more extended services. Same was true of the second form of legal help, Avvo Legal Services. So this is what it launched in 2016, now does: fixed fee assistance for a specified need like employment, contracts, or divorce. And once the consumer identifies one of those areas, a list of the fixed fees come up. So if you're trying to start a business, you get a 15-minute business advice session and assistance in how to start a limited liability corporation. And after choosing the service, the consumer then chooses the lawyer from a list of lawyers who are reasonably geographically close. And the website has a short description of their Avvo page, which has clients' ratings and their experience. So after the consumer chooses a lawyer, pays the fee to Avvo, the lawyer has to get in touch with the consumer within a day, and the participating lawyer can then decide whether to take the case. And then after taking the case, the lawyer deposits the full fee, and Avvo takes back a marketing fee, which varies depending on the cost of the services. So here are some sample services. For a corporation, you got $600, $125 for a marketing fee. A document review is $200 for a $50 fee, and so forth. Avvo offers a satisfaction guaranteed for services within 90 days of purchase, and the client who is dissatisfied can either get a refund or a different lawyer. So taken together, all of these activities have made this company, by its own account, the web's largest and most heavily trafficked legal resource, with over 8 million visits per month. And despite, or perhaps partly because of that success, it's also the company that's drawn the most bar regulatory conflict. And by the fall, this past fall, ethics committees in 6 states had all issued opinions condemning certain aspects of the plan. And there's a kind of irony to all of this because bar regulators have been unable to resist the technological innovations that are in direct competition with lawyers, computerized forms and sources of free legal advice. But they've had a much higher success rate from a technology that seeks to bring lawyers and consumers together, albeit at a much lower price, which could benefit lawyers, the underemployed and tech-savvy practitioners. So what accounts for this kind of anomalous outcome? I think one explanation is that bar regulators are the most powerful when regulating licensed lawyers rather than non-lawyer competitors. So, for example, when LegalZoom got a cease and desist order from the North Carolina bar, it just plowed on and eventually challenged the bar in courts. But by contrast, the bar ethics opinions that condemn Avvo Legal Services put participating lawyers at risk of professional discipline, and many of them may be reluctant to assume that risk. I think another reason that the bar has targeted Avvo is that lawyers serving individual consumers really have long hated price competition. For years, bar associations published mandatory fee schedules and banned advertising to avoid this competition. Now, Avvo has created national fixed price points for a large number of bread and butter legal services, and if it catches on, other lawyers are going to have to match those prices or explain to consumers why they should pay more, which I think partly explains why the bar regulators in 5 states have condemned the programs that are part of Avvo Legal Services. It does not appear that any of these committee opinions solicited comments for clients or consumer groups, with one exception, which did at least ask consumer groups but didn't get any indices of consumer harm. Although these opinions are advisory only and they're not binding precedents in future enforcement actions, they can be considered by a regulatory authority in those actions. And although no regulatory body has yet filed charges against Avvo or the lawyers who participate, the existence of the opinions and the threat of disciplinary proceedings is a real chill and is discouraging a lot of practitioners from taking Avvo referrals. Well, there are a number of stated concerns. Pennsylvania's Ethics Committee lists 11 possible violations of state model rules and professional conduct. Some of the concerns seem highly speculative, unlikely to pose any real risk of consumer injury or are subject to some easy technical fixes. And because time is short and I want to leave a lot of time for discussion rather than get into the weeds, I'm not going to discuss all those, but just a couple of the objections that I think are the most significant and which may well have traction. The most substantial objection to this innovation is fee sharing. All of the bar ethics opinions have addressed this issue, and all but one concluded that Avvo's program violated ethical rules because participating lawyers pay back part of their fee to the organization. The vast majority of states have a version of the model rules of professional conduct which prohibits lawyers from sharing fees with non-lawyers or giving anything to value to a person for recommending the lawyer's services. The rule has a couple of exceptions, one of which is that lawyers can pay the reasonable costs of advertisements. And Avvo has responded to these complaints on 2 grounds. First of all, they say that there's nothing inherently wrong with fee splitting, that they only become a problem if the fee is split with a party that might pressure the attorney's decision-making in a given case. And that's not obviously the problem here. The difficulty with that response is that's not what the model rules say. It doesn't say, there's an exception if you don't interfere. They say you can't do it. So the second line of defense is that the marketing charges are permissible because they fall under the exception for fees reflecting the reasonable cost of advertisements. The problem with that is, as the Pennsylvania Legal Ethics Committee noted, the cost of advertising doesn't vary depending on the amount of revenue that's being generated by a given matter. Yet Avvo's marketing fees vary a lot. $10 for an advice session costing $39 to $400 for a green card application costing $3,000. Clearly, the Pennsylvania Bar Committee said, doing the math, the advertising and administrative costs for these two services do not explain a $4,000 variance in the price. The variation in the amount of marketing fees based on the amount of the fees earned by the lawyer establishes that the non-lawyer business is participating directly in and sharing the fee income generated by the lawyer, and that's impermissible under the model rules. And I think any bar ethics committee that reads the model rules literally is going to end up where the Pennsylvania committee did. So are there ways around the problem? Well, Ben Barton and I suggest a couple. One is for Avvo to change its marketing fee to reflect a flat rate based on a pro rata share of its advertising costs, not a rate that varies with the amount of the client's charges. But this, of course, makes absolutely no sense from a business standpoint. A lawyer who's already receiving only $39 for an advice session and other low-cost services isn't going to want to pay a substantial marketing fee or the same one that an immigration lawyer who's charging $4,000 is willing to pay. And Avvo's leadership believes that this and other proposed changes by bar ethics committees would make the product worse for both consumers and lawyers. A second possibility is for bar ethics committees to do what the North Carolina bar did and view reasonable advertising costs as a kind of umbrella term to cover any marketing expenditures. In our view, however, the best workaround would be for bar regulatory bodies to consider both the ethical concerns underlying the rules and the public's interest in cost-effective services. And they should make that inquiry after getting input from clients and consumer organizations. Rather than speculate about possible harms, they should ask for evidence of purchasers' experience. If significant harms occur or can be reasonably expected to occur, bar regulators ought to be looking for ways to address them without compromising consumers' access to affordable services. So that's kind of where we end up with Avvo, and let me close with a couple of heretical observations about why we believe this is in the profession's as well as the public's interest. Recent data suggests that lawyers who serve individuals of modest means are spending about a third of their time on developing or finding clients and about half of their time on administrative matters, keeping their license current, managing an office, generating and collecting on bills and related tasks. That leaves only 20% of their time to actually substantively practice law. These lawyers really need all the help they can get in minimizing marketing and administrative costs, and Avvo is one way to do that. It finds the clients, and it handles all those matters of collecting the fees. Why, then, is there so much hostility from bar regulators and the rank and file of the profession? Well, as I've suggested earlier, I think it has more to do with price than ethics. Avvo Legal Services is replacing billable hours with a flat fee for a wide range of services, and flat fees that are relatively low. And so many practitioners who serve this client base are worried that they're going to have to match those prices or lose business. And for lawyers who serve individual clients and are active in bar associations, moving to lower fixed prices may seem like a disaster. But I think what this response leaves out is the obvious fact of what's happening already. Rocket Lawyer and LegalZoom are already radically lowering the prices for many routine services. That horse is out of the barn. Avvo Legal Services is attempting to compete with these online form preparation services by connecting clients who'd rather hire a lawyer if they can find one who will do it at affordable prices. Lawyers and bar regulators who hope that prohibiting participation in Avvo Legal Services is going to hold the line against technology-driven competition have it exactly backwards. Programs like Avvo Legal Services are the profession's best hope of growing the number of clients willing to pay a lawyer to do work and compete with online forms. There are, of course, other broader public benefits by enhancing access to justice. Given prevailing average fees, most Americans can at best afford a little more than a few hours of lawyer's work on any issues. American lawyers have contributed to the persistent and pervasive problem by using hourly rates that seem to reward them for maximizing their time rather than their efficiency. So part of the answer to competing with technology is for more lawyers to serve more clients at more affordable rates, and technology can serve that end. LegalZoom and Rocket Lawyer are doing exactly that, and the sooner that lawyers can follow suit, the better off that they and all of the rest of us will be. So I think these innovations are a step in the right direction. They lower the price of legal services. They give consumers an accessible way of identifying a lawyer and determining if they can afford one. It encourages lawyers to work more efficiently, because the only way to make a living through a service platform like Avvo Services is to handle a large volume of cases quickly and effectively. Bar regulators ought to be waiting to see if problems materialize and then looking for the least restrictive ways of dealing with them. The regulatory process should be more evidence-based and open to comments from affected parties. Snuffing out innovation before it even launches seems calculated to protect the profession, not the public. And as we argue, I think even the profession in the long run is ill-served by that kind of regulatory repression. So thank you all, and let me open it up.
I'm a founder of a company called Oasis Financial that's involved in third-party financing. Thank you for making me a staunch Avvo supporter with your comments. I'd be interested in your perspective on the professional rules that bar non-attorneys from taking interest in a law firm.
Well, you know, I should hesitate to say that I just used Avvo as a case history because it's the one that's gotten the most bar regulatory repression at the moment. It's not because I'm, you know, pitching the company per se and don't want to be held accountable for every other thing, perhaps wrong thing that they do. But in answer to your question, that's a little out of my wheelhouse, but I think the general principles that I articulated are the right ones, which is that the bar has, you know, just swept way too broadly with regulatory restrictions without looking to see whether the problems have actually developed in the context in which it's regulating. And that's as true as investment in law firms as in other places. And I think in a lot of these areas, multidisciplinary practice is another one. We can learn from jurisdictions that have more permissive rules and are allowing innovative financing, and let's see if anybody's getting screwed as a result. So the bar really needs to get out of the way here and respond to actual harms from the public, not from the lawyers who were threatened by innovative financing structures. I don't know if that's a specific enough answer, but.
That's perfect, thank you.
Okay. Yes.
I am 100% in agreement with what you're saying, and you missed my fight with the president of the American Bar Association this morning. But
I heard a little, and I talked to her after her keynote. We had a heart-to-heart on issues of bar regulation, so I'll share what she said, but go ahead.
But putting the best face on the other side of this, the view about the problem with interviewing consumers, whether they're looking for consumers of medical care or legal services, is the view that they're not the best judges of the quality of the legal service they got, especially if it's something like a will or something else where they're really in a tough position to judge what they got. So I would just be curious about your response.
I certainly acknowledge that point. But, you know, patients are usually not in the best position to make informed judgment about quality of medical care, but we don't make them all go to high-priced services. If they want to see a chiropractor or a quack, you know, with, you know, some restrictions on, you know, misrepresentation or fraudulent products, we let people make decisions about the amount of medical services that they want to provide.
You don't take what drug they want, though.
Well, as I say, you know, where there's severe safety issues, but we let them pick the service provider. And, you know, somebody did a study many years ago and got different lawyers to compete over doing a routine service. And what they found was that the clients who went to the high-end practitioners, you know, got Cadillac service, but, you know, it was like 8 times as expensive, and they didn't need Cadillac service. As the, you know, bottom line survey finding says, you know, you don't need a surgeon to pierce an ear. And that's true with routine services. Also, the alternative now is that consumers aren't going to go to the higher-priced lawyer. They're going to go to the online systems where they're equally ill-equipped to make judgments. Or go without, and we know what happens there. So, you know, I think asking what's the alternative is got to be part of the calculus, and that's what the bar hasn't done. I did talk to Hillary Bass, and in fact, I shared this keynote with her because I knew we weren't going to overlap. And she said, oh, yeah, well, Pennsylvania. that was the one that found 11 ethics violations. They're hopeless, she said. You know, it's not really the ABA's fault as much because at least the leadership of the ABA, they don't have a dog in this fight. They care about access to justice, and their livelihoods are not at risk. But the rank and file members of the ABA, the House of Delegates, you know, their position on non-lawyer competition has been hostile and consistently so, and I don't think is likely to change. And to the extent that state bars are drawing from that same constituency, the people at risk, you know, it's going to be a tough slog. And that means changing bar politics at the state and local level, as well as pushing the ABA, especially the leaders of the ABA, who are often, you know, on board with the need to change, but can't muster the troops and don't control the ethics committees. Other questions? Thank you.